Hello, everyone. We are going to call this meeting to order. Today, it's 1 o'clock, or 5 after, if you'll excuse the delay. This is the Metropolitan Short-Term Rental Appeal Board monthly meeting, and we are going to hear from Mag here with some housekeeping about how the process is going to work today, and then we'll get going on the cases.
Thank you, Chairperson. Good afternoon. The Metropolitan Short-Term Rental Board of Appeals is now in session for the regularly scheduled meeting of March 29, 2023. I'm Bonnell McBroom III, Short-Term Rental Chief for Metro Codes, and I will be presenting the cases to the board for review in today's public hearing. At this time, I would ask everyone to either turn their cell phones off or to place them on silent as to not disrupt today's meeting. The procedure will be for staff to introduce the case record. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to the case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board in their rules provides the appellant in cases without opposition 5 minutes to present their case. In a contested case, the board provides 10 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some of their allotted 10 minutes for the rebuttal. The Metro Code requires that the proceedings are taped. Therefore, it is imperative that everyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of show cause hearing. The board will go through the cases set for the public hearing today. After both sides of the case presentations are made, the board will discuss and vote on the case. The board is vested with the power to act on these cases before us today under the provisions as outlined in section 6.28.035 of the Metropolitan Code. The code requires 4 members of the 7 members to be present to constitute a quorum. The board rules require a majority vote in the affirmative of the members present to grant appellant's application. In the event that a majority vote is not achieved, the case will remain on the board's agenda for the next regularly scheduled public hearing. Applications that fail to receive a majority affirmative vote at the next regularly scheduled public hearing shall be deemed denied by operation of law. The appellant or any aggrieved property owner may request a hearing within 60 days of this public hearing. Further, the appellant or any aggrieved property owner may also appeal to the board's decision to chancery court within the same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you have applied. It should be noted that a permit must be obtained within 2 years of the board approval to remain valid. I submit that all cases have been filed in proper order. The appellants have been notified by certified mail as required by the code. All affected property owners have been notified by legal sign notification requirements and legal notification and sign requirements have been met as required by the code. At this time, we'll ask if there are any elected officials present to make a statement to the board. Seeing none, today's agenda initially had 6 cases on it. We are down now to 2 cases. The 4 cases that have been removed we'll be hearing the first case, 2023-52. The second case, 2023-55. The third case, 2023-56, have been withdrawn. We will be, 2023-53 has been withdrawn. 2020-54, Derek Hall, has been withdrawn. We will be hearing 2023-55 2023-56. So without any further announcements, Chair Caputo, we are ready to proceed.
Terrific. Okay, so let's call case 2023-52. Do we have anyone here for Steve Wittick, Stahlherber, excuse me, I'm butchering that name. Gary, okay. If you could come here to one of these two chairs. Is there anyone here in opposition to this case? Okay. Very good. So as Mr. McBroom said, please make sure that you state your name and your address for the record and tell us about your situation. And do keep an eye on the, if you'd want to share those with us, Joey will take care of it for you. And, do be cognizant of the time because we're going to be strict about that.
And staff will make their presentation
I'm
first.
so sorry. It's been a long time since we actually heard a case. I forgot. We are going to hear from Mr. McBroom first, so hold that thought. Sorry about that.
So we're hearing case 2023-52, Stephen Wittick at 1827 Willow Springs Drive. This permit was revoked due to the property not being the permanent or primary residence. For an owner-occupied permit, this is a requirement. This is an R10 where only owner-occupied permits are allowed. This is governed by BL 2020-187, which took effect on 7/10 of 2020. And there is an automatic 1-year wait whether or not the zoning administrator erred in revoking the permit. So the decision for the board today is not whether they shall lessen the period, but as to whether or not the zoning administrator erred in revoking the permit. On March 24, 2021, Gary Michael and Catherine Stahlheber acquired 1827 Willow Springs Drive. The deed of trust has a multi-state second home rider, which states, in addition to the covenants and agreements made in the security instrument, borrower and lender further covenant and agree that the sections 6 and 8 of the security instrument uniform covenants are deleted and replaced by the following. Those sections are Section 6, occupancy. Borrower will occupy and use the property as borrower's second home. Borrower will maintain exclusive control over the occupancy of the property, including short-term rentals, and will not subject the property to any time sharing or other shared ownership arrangement or any rental pool or agreement that requires borrower either to rent the property or give a management firm or any other person or entity any control over the occupancy or use of the property. The borrower will keep the property available primarily as a residence for the borrower's personal use and enjoyment as for at least 1 year after the date of this second home rider, unless the lender otherwise agrees in writing, which shall not be unreasonably withheld, or unless extenuating circumstances exist beyond the borrower's control. Section 8, borrower's loan application. The borrower shall be in default if during the loan application process, borrower, any person or entities acting at the direction of the borrower or with the borrower's knowledge or consent gave materially false, misleading, or inaccurate information or the statements to the lender, or failed to provide the lender with material information in connection with the loan. Material representations include, but are not limited to, representations concerning the borrower's occupancy of the property and borrower's second home. The deed of trust is included in the case summary packet with the pages that lack relevance to this case excluded for the sake of brevity. However, I have them here today if they need to be reviewed or if there is question concerning them. Based on the obituary that follows the deed of trust in your packet, we believe that Mr. and Mrs. Stahlheber were Mr. Wittick's mother and stepfather. The obituary for Wilbur Stahlheber lists survivors Gary Stahlheber and Kathy Wittick. This appears to have been borne out by the affidavit for the short-term rental submitted with the initial permit application package, which was for a not owner-occupied permit. The affidavit for short-term rental signed by Catherine Stahlheber authorized Sarah Weedick to apply for a short-term rental permit for the property at 1827 Willow Springs Road. On February the 15th of 2022, a not owner-occupied STRP permit application was submitted. On February 25th of 2022, the application package was reviewed by Program Manager Robert Osborne. The application package included a non-owner occupied STRP affidavit filled out in the name and signature of Sarah Weedick, a short-term rental permit application, homeowners association certification filled out in the name and signature of Sarah Weedick, a short-term rental neighbor notification letter from the owners, Gary and Catherine Stahlheber at 7208 Eaton Oxford Road, Camden, Ohio, with the name Sarah Weedick in the signature line. Finally, the application package included the Tennessee driver's licenses for both Stephen and Sarah Weedick with the address of 1825 Willow Springs Drive. This application was rejected based on the fact that not owner-occupied permits are not available in this R10 zone district. Mr. Osborne communicated this to Ms. Sarah Weedick by email as the application had been submitted by email. Ms. Weedick emailed back the following. Hello, Robert. I thought we bought our neighbor's house with my in-laws last year, and coincidentally, my husband and I are separated. When he is not traveling for business, which is weekly, he stays there. It's a split-level home with 2 full kitchens and 2 full bathrooms. I didn't know how to communicate this in the application. He changed his address for a new employer to reflect 1827 Willow Springs Drive, as well as voter registration. The utilities are in his name. Does he need to change his driver's license as well? On March 24th of 2021, a quick claim deed was recorded, which added the appellant, Stephen Weedick, as an owner of 1827 Willow Springs, along with Gary M. and Catherine Stahlheber. On April 5th of 2022, an owner-occupied permit application the application package included a copy of a quitclaim deed, the affidavit for the short-term rental, whereby Stephen Weedick authorizes his wife, Sarah Weedick, to apply for the short-term rental permit. The Homeowners Association certification with both the names of Sarah Weedick and Stephen Weedick. The proof of residence that was submitted for the permit was Stephen Weedick's new Tennessee driver's license and the address of 1827 Willow Springs, and Stephen Weedick's voter registration. The permit was issued on that date. Sarah Weedick was the applicant for this permit that was issued to Stephen Weedick and for which Mr. Weedick provided proof of residence documents. On May 16th of 2013, 1825 Willow Springs Drive, now this is 2013, bear in mind, 1825 Willow Springs Drive was acquired by Stephen Weedick and wife Sarah Christine Lerner Weedick. The deed of trust for the property has in the uniform covenants number 6, which states, number 6, occupancy, borrower shall occupy, establish, or use property as the borrower's principal residence within 60 days after the execution of this security instrument, and shall continue to occupy the property as the borrower's principal residence for at least 1 year after the date of the occupancy, unless the lender otherwise agrees in writing, which shall not be unreasonably withheld, or unless extenuating circumstances exist beyond the borrower's control. The deed of trust is included in the case summary packet with the pages that lack relevance to this case excluded for the sake of brevity. However, I have them here today if they need to be reviewed or if there's question concerning them. On August the 12th of 2022, 6 months after the owner-occupied permit was issued for 1827 Willow Springs Drive, an owner-occupied STRP permit application was initiated. The previous STRP permit for this property had expired on 6/17 of 2022. The applicants were listed as Stephen Whittick and wife Sarah Christine Lerner Whittick with the address of 1825 Willow Springs Drive. The property tax bill from the Metropolitan trustee lists Stephen Whittick and wife Sarah Christine Lerner Whittick with the address of 1825 Willow Springs Drive. The proof of insurance documents list named insured Stephen Whittick, 1825 Willow Springs Drive, Nashville, Tennessee, 37216. Supplementary name Sarah Whittick. Proof of residence given were a bank statement and Tennessee driver's license for Sarah Whittick. On October 18th of 2022, a short-term rental hotline complaint for 1827 Willow Springs Drive, which stated, calling to advise they have a false permit as they do not live there. Inspector John Feltz opened an investigation. Initially, he found most of the deeds and permit application documents previously outlined in this summary. The appellant has the following vehicles registered in his name at 1825 Willow Springs Drive: 2016 Subaru Outback, 2007 Toyota Tundra, 2016 Toyota 4Runner. December 2nd of 2022, Inspector Phelps made a site visit to the property and found Mr. Whittick's white Toyota 4Runner parked at 1825 Willow Springs Drive. And Inspector Phelps made photos. We presented this evidence to the zoning administrator, and he deemed it to be sufficient to revoke the permit. The letter, on December 27th of 2022, the letter of revocation was sent. By law, the Codes Department is required to give 15 days notice before the revocation goes into effect. Therefore, the revocation went into effect on January the 11th, 2023. As mentioned earlier in this case summary, Ms. Whittick claimed in an email of February 25th, 2022, that the Whitticks were separated after a non-owner-occupied permit application was rejected. Mr. Whittick made the same claim in an email on February the 1st of 2023, almost a year later. We conducted a document search with the court clerk and found no documents to substantiate those claims had been filed. We told Mr. Whittick that we found no documentation. He gave us the name of a mediating attorney. Inspector Phelps called the attorney's office and left messages, but his calls were not returned. Inspector Phelps went to the attorney's office but was unable to see the attorney. He told the appellant that he could not make contact with the attorney. February the 7th, 2023, the STRP appeal was filed. The Airbnb ad for 1825 Willow Springs Drive host profile photo and ad photos do not substantiate the claim. The VRBO ad does not either. You should notice all the photos that the children's notice from all the photos that children's playground is located at 1825 Willow Springs Drive address. The host profile page photo on Airbnb, on the Airbnb ad for 1827 Willow Springs has been changed from the Cached ad from January 19th, 2023, as you can see in the case summary packet. However, it has both Mr. and Ms. Whittick in the photo. Mr. Whittick's Facebook page has photos posted from August 31st, 2022, October 13th, 2022, and November 16th of 2022, which give no appearance that Mr. and Ms. Whittick are separated. The Whittick's Facebook also seems to contradict claims when you view the photos when you view the photos and see where at 10:31 p.m. on February the 4th, 2023, Ms. Whittick writes, Steve and I are evolving in our short-term rentals. I am able to focus more on our business side of our listings for a bit more. On March 15th, 2023, 3 of the neighbor notification letters that were required to be mailed by the appellant well in advance of the hearing date for the SDR appeal case to be eligible to be scheduled on the docket were returned because they had been mailed without postage. I emailed the appellant and informed him that the hearing for his appeal case would be changed to the next scheduled SDR board meeting as notification requirement had not been met. He asked if he could rescind the letters and remain on this docket. Given that it was 14 days until the meeting, I told him that if the letters were mailed on that day or the next at the latest, the appellant complied and emailed a photo of the letters with postage and stamped by the Postal Service on March 16th, 2023. In fairness, I must include that on March 20th, 2023, Inspector Phelps and I both received an email from attorney Jessica Doyle in which she states, "Hi, John. That's Inspector Phelps, I am reaching out to confirm that I am the mediator and lawyer handling the Weedick versus Weedick mediation. They are currently in divorce proceedings. Thanks, Jessica Doyle." Even though this was submitted after the 14 days prior to the hearing deadline for submissions by the appellate, I included it in the summary. We took this to the zoning administrator, and he said that the divorce has to be final before an owner-occupied permit could be issued on the property. There was one documented complaint for 1827 Willow Springs Drive, which was read earlier in this summary, and the short-term rental board email box received 3 emails for this appeal. 2 were in support and 1 in opposition. Subsequent to this writing, I believe that there were 2 more emails received, and they were forwarded to all of the board members by email.
Members of the board, Joey Hargis, Metro Zoning Administrator. I want to add just a couple of things just to sort of flesh out and give a little more color to our process internally that you guys may not see. But I think it's a good opportunity to educate the public who are going to watch this and kind of how ultimately decisions I have to make, whether I believe or disapprove. We'll have some training, I think some ethics training coming at the end of today's meeting, and in that case will be a case called Dewey versus Sumner County, or Sumner County versus Denny, excuse me, thank you. I won't bore you with the facts of the case. Long story short, back in that time, the state of Tennessee, counties taxed people on personal property and real estate, and the gentleman lived in Trousdale and moved to Sumner to take his kid to school, and both counties were trying to tax him, but so the Supreme Court of Tennessee laid out what a domicile is. So forgive the gendered language. It's 1906 or 08. It's a long time ago. I apply that same sort of standard to both males and females likewise. In Mr. Weedick's case, I did make a determination that once their divorce is filed, and I have a brother going through this, so I'm sorry for this that you're going through. But once they're final, both parties will be eligible for owner-occupied short-term rentals. So I want to encourage him, no matter the outcome of today's proceedings, once his divorce is final, we will accept an application for him at his new property. But to be fair to him, I want him to offer the opportunity to appeal before you today. So hope that helps. Give a little background what we do. I think the council, in their wisdom, created this system of permitting and committed this system of rules. We can, as imperfect humans, we can't come up with all scenarios that could possibly happen, but these are the things that I and my staff deal with daily, of things in life that happen. Do they live here? Do they not live here? I try to give as much weight as I can to the facts in the case before I make a decision. But I always offer the opportunity to come here and appeal to you guys. So with that, I'm done. Hope that helps.
Great. Thank you. Okay, anyone have any questions for Metro before we hear from the appellant? No? Okay.
Mr. Weedick, you have 5 minutes for your presentation.
Thanks again for the opportunity, and I appreciate your time. I feel like there's a lot of gray area, and
Sir, excuse me, would you state your name?
Oh, I apologize. I'm Steve Wadick. I am the resident at 1827 Willow Springs Drive. My wife and I have been going through a separation, not legal separation, so we've been separated for over 2 years, and it's been hard. We've lived together for part of that. We tried nesting. It didn't work. I wasn't familiar with that term, but it's, separate rooms, and you try to keep things normal for the kids. So we do live in separate residence. I used to live at 1825 Willow Springs Drive. My kids still reside there. I still read to my 5-year-old at night. I still have dinner with them sometimes. This is an amicable divorce. I understand how the rules are set up, and I understand and I appreciate that corporate conglomerates can't come in and own neighborhoods and have Airbnbs. But this Airbnb, both of our Airbnbs are crucial to the neighborhood. We have Riverside Mansion right there. People stay there for weddings. We have visiting families that come, and we're the overflow. Our Airbnbs are overflow for our neighborhood. But more than anything, it really helps both of our families, and it has for years. And we've ran 1825 for almost 9 years now, and we've had tremendous success with it. So I like the platform. It's not perfect, but none of this is. I just want to pull a couple items here that really came to my attention going through this. We bought 1827 with my parents with the intentions of renovating, not sure if we're going to flip it, not sure if we would Airbnb, how we could do that legally, all through of which going through a divorce. As things progressed, Sarah and I have been in counseling for 12 years, and been married 10 of those years, and we're better not together. So I have been living next door at 1827 Willow Springs Drive. I travel for a living. I'm gone 150 nights a year, so I'm gone the majority of the time. So when I'm gone, I want an Airbnb if I can, possibly. Sarah was still would still be managing it because she does a great job with that. Yes, she filed the wrong application on 2/22. My parents have, since they know we're getting divorced, they've changed their trust and their will to put me as their heir for that property. Going through this, I think the first and the biggest complaint is when I received this notification with the cease order on my door. This was the first time I saw this in January. This did not come to me in December. We did not leave, I did not leave my house. Sarah didn't leave hers. We played in the snow. This did not come to me. This was posted on my door in January. It still has the tape on it. I never received anything else, and that was the first I realized that I was not in compliance or someone, because also my Toyota 4Runner, it's a shared car. I was driving the Subaru Outback to work during November, December, even into January, until Sarah bought a new vehicle, and she bought a van, and it's nice. So now she has a minivan. So to say that my car, which is a shared car, is not in the right driveway. And then additionally, I guess I'm frustrated with the point of someone telling me that I have to be divorced before I can get a permit. I don't understand how that's legal. I don't understand the bearings of it. Even if my wife and I stay together and we live apart, why can't we live apart? And we're getting a divorce. But I just don't understand. I don't understand that hard line. And, that's kind of where I'm at with most of this. If you go back and look at my Facebook, which I think is very strange, to be investigated on a social media platform for my ring. I wore my ring for my children because we hadn't told them that we're getting a divorce yet. They knew we were living apart, but I wore my ring to protect my children, and that is my job. And I don't apologize for wearing that wedding ring until I knew I was getting a divorce. And that's kind of where I stand. So sorry.
Thanks so much. Your time has elapsed. Okay. Anyone have questions for Mr. Whittick? Oh, yeah, please go ahead.
So for staff, is the determination that Mr. Whittick does not live at 1827, or is the determination that the paperwork is not in order to prove that he, or to establish that he lives there?
The overwhelming amount of paperwork that ties Mr. Whittick to 1825 is what we base the case on. And then in addition to that, the deed for 1827 was conveniently changed after the not owner-occupied permit was denied. So it's a thing that we see quite commonly in Nashville, especially since January 1st of 2022, when no residential areas are able to obtain non-owner-occupied permits. I can certainly understand it being lucrative and people making efforts, but the ordinance is clearly written that it has to be your primary residence, and that's what we have to go by. And the only thing that we have to go by is we don't go out looking for this. We're completely 100% complaint driven. When we get a complaint, we are bound to investigate. Therefore, we investigate. How do we investigate? Documentation, legal documentation is our first step. That is our primary driver, and then following that, we try to fill in any gaps with social media or anything that's available on the internet that's publicly available. We do not try to delve into anybody's private documents by any means. Only publicly available information. That's our job, that's how we do it, and that's why we do it.
Thank you. And a follow-up question for staff. I'm trying to scroll through the packet here, and I can't quite find the thing I'm looking for, but I did see as I was reviewing that, there was a notice that went out at some point that a hotline complaint had been filed.
This was the notice of revocation, which Mr. Whittick says he did not receive. Now, we send it. If it's not received, we can't. But in any event, the date on that's December the 27th of 2022.
Thank you.
And Councilmember Parker, I just want to add, as far as Mr. Weedick, is it Weedick? I want to make sure I pronounce it. My last name's Hargis, and that gets butchered. Weedick. I get butchered all the time. The council, in my role as zoning administrator, council did not give us specific, hey, if this happens, do this. If this happens, do this. The case I spoke about, Denny v. Sumner County, it is an old case, but it says two things, and it leads to the word domicile. And this is a direct quote from the case. A man may have two or more residences, but only have one domicile or legal residence. He must have a domicile somewhere. He can have only one. Therefore, in order to lose one, he must give up another. Okay? And that is where the sort of the policy I've come from, that husbands and wives that are still legally married have one place. I'm using that court case as my basis for that in a world that I understand that things go on between husbands and wives and they're separating, but until that separation is final, there's only one domicile for this gentleman, and that's the married residence. He could not buy another. Otherwise, we may have an epidemic of folks living apart, buying houses in neighborhoods, and I live here for 2 months and there. We've got to have some sort of means of doing that, and I use this Supreme Court case here to find that. As I stated at the beginning, once they're final, we're happy to issue a permit. We'll judge his application on his own at that residence and her application at her residence.
So, Mr. Hargis, to be clear, your determination that the divorce has to be final is based on an extrapolation from the Denny case and not actual code?
That's correct.
Okay.
Yes, sir. And zoning administrator, one of the duties I'm tasked is interpreting, enforcing both when this section lived in Chapter 6 or in 17, but as the Chapter 6 code appoints me as sort of the determiner of what does this mean. Right. Ultimately, it's you guys via the appeal process. If you disagree with me, great. It sets me, okay, next time I'll handle it this way. So I always encourage people to appeal if they disagree with me. I take there's no personal.
Sure.
I don't care. Let's get the right answer. Whatever.
Are there
that is.
cases since the Denny case that have treated the issue with any greater depth? Sort of.
I could find none, and I'll certainly defer to legal counsel. I could not find a more pertinent case or more case on point, a more modern case, if you would say.
Anyone else on the board have a question for the appellant or for staff?
Did you and your wife file your taxes together, or did you file them married filing jointly, or tell me how you filed your taxes?
Currently, we are still discussing if we're going to do married separately or jointly. Our attorney recommended doing it jointly for 2023. So we still were jointly 2022 because the Airbnb income, regardless of, it was 50-50. So we decided to do it jointly, yes.
So when you filed your taxes in 2022, it had 1825 listed as your address?
My W-2 is 1827. I don't know, just like at the DMV, I handed my ID to the DMV. They didn't change 1825 to 1827, and I actually forgot to tell them. So they had my ID when I just registered my, the Toyota is a newer car, and I gave it to them, and we both failed to see the difference. And that's why when I got notified in the packet of the 1825 still on my car, I was like, well, man, that was only like 3-4 months ago. And I didn't catch it. They didn't catch it. So going forward, it will be 1827 regardless. But to answer your question, it was 1825 for 2022.
Okay, thanks.
Any other questions? No? Okay, thank you so much for your time. We're going to discuss amongst ourselves. And unless we reopen the public hearing, there will not be another opportunity for you to speak. Thank you. All right, folks. What do we all think? And I would like to point out, and it is captured here in the docket, that our task, our role is quite limited simply to the question of whether or not the zoning administrator erred. That is the only question before us. That is the only thing we're deciding.
I can begin if
Please.
so this is
My brain's buffering right now.
this is clearly a complicated case. There's a lot of documentation to review and whatnot. I can only look at the evidence that was presented to us by staff and can only take what the appellant has told us. I've never drove by this house or gone and asked the neighbors what's going on there or anything like that. So just based off the information that we have here today, I'm going to have a hard time thinking that the zoning administrator erred in this case because of the evidence in terms of documentation. I understand that they are, exploring a divorce. They're still filing taxes together. They appear to be operating the Airbnbs in sort of a continued partnership, regardless of the outcome of that divorce. And I don't see sufficient evidence to overturn the zoning administrator's decision in this case. I also am wary of setting precedent that would allow, we already see a lot of folks, as staff pointed out, claiming 2 different addresses for the purposes of getting owner-occupied permits. That is relatively common. I do a lot of reviewing of the permits in my district, and I see it a lot. So I'm open to other thoughts and discussion on this, but that's where I'm at.
It's a tough one for me. I think that I understand the need for some hardline rule for a lot of the reasons that you explained, Councilmember Parker, but you know, also, this is a lot of trouble to go to. It's a lot of trouble to go to not really be planning for that to be your primary residence. Also, if Mr. Weedick is gone 150 nights out of the year, I could see how it would appear to a neighbor too that he doesn't live in the house. You know, which is, according to staff, the genesis of the complaint. I'm not saying I've made up my mind one way or another. I'm just saying this is a tough one.
I would concur. I feel like I feel like the evidence kind of militates in both directions, honestly. And I'm also not entirely certain that I see this case as analogous to the situation in Denny, such that I agree with the zoning administrator that a divorce is a necessary event before an owner-occupied permit can be successfully applied for. I'm not sure that I agree with that whatever the circumstances were. I've not read the Denny case, but I'm not certain that I agree that whatever the circumstances were in that case are similar enough to this situation that they would govern. I'm also not certain that when the rules for owner-occupied permit issuance were conceived that they had in their contemplation a situation like this. So it just makes it incredibly difficult to come down clearly on one side or the other for me.
I'm not having as difficult a time.
Okay.
Simply in that I feel our task is quite simple, and it's did the zoning administrator err? And the evidence is overwhelming that they would be led in this direction. And for all the evidence that was garnered, and I understand that the appellant is a little perhaps insulted by some of it being garnered from social media, nonetheless, there wasn't anything that told a different story. So how could the zoning administrator have made any decision other than the one that he did? And I think we don't have an opportunity to decide anything other than did the zoning administrator err? And I don't see that in this case he did.
I think for me, deciding the error in this case is different than deciding the error in other cases, because it's an extrapolation from a case interpretation. It's not something, as Mr. Bond pointed out, it's not something that's in the code. And so for me, that makes my decision harder.
Mike, anything?
Yeah, I kind of agree that based on the evidence that was found at the time of the investigation, that there was not an error made by the zoning administrator. That doesn't mean that in this evolving situation that it may change. The circumstances are definitely changing. Also just recently went through a divorce, and I know how it takes a long time, and there's a lot of things where you're listed as both married and separated or divorced simultaneously, which could be very confusing. I would obviously encourage the appellant to reapply for an owner-occupied permit.
I would agree with Mike. I also think that this case is really difficult.
It is.
It puts us in a very weird position to, again, set precedent, do we or not?
And actually, while Mike was speaking, I think I've finally settled into position. For me, the difficulties remain, and absent greater clarity in the code, I just can't, in good conscience, say that I'm convinced enough that the zoning administrator did not err. So I think I'll feel comfortable voting accordingly.
I think ultimately, at some point, we do have to be concerned about setting precedent, but also for someone to come down here with children and go on the public record and say, my wife and I are getting a divorce. This is how we're handling it. You know, could somebody come down here and lie about that? Yeah, they absolutely could. But for me, I just don't see how somebody's going to come down here and say that if it's not true. I don't, and I think that that is very telling, in my opinion.
Okay. Does anyone want to make a motion in one direction or another?
I'm comfortable moving that the zoning administrator did err and that we should vacate the decision.
Seconded.
Can I see a show of hands on this motion? The motion does not carry. Do we have any other motions?
Within the limited scope of what's before us to consider, the other motion would be that the zoning administrator did not err.
Are you making a motion to that effect?
I'll move that the zoning administrator did not err.
And I will second that. Can I see a show of hands those who believe the zoning administrator did not err? Okay. The motion on that carries. I think this is the first time we've had so much disagreement, so I think it speaks to the complexity of the case. But I think Councilman Parker's comments and Mike's comments were perfectly on point, that when this matter is a little more settled in the family situation, it can be a little more settled in codes and zoning. So,
And two, these part of why I appreciate serving on this body is that, you know, if there are opportunities for us to provide more clarity in the code for cases like this, I'm going to work toward doing so. So I do appreciate the discussion and staff giving us as much information as they did about how they came to this decision in this case.
Yep, absolutely. All right, very good. Well, Mr. Weedick, thank you so much for your time today, and I'm sorry it didn't go the way you wanted to, but we wish you the best of luck. Thank you. Okay. So, turning to case 2023-56, the Robinsons. Good afternoon, gentlemen.
Is there opposition to this case? Therefore, each side will be allotted 10 minutes. Staff will present the case. W. Daniel Robinson, 3017 Hillhurst Drive. The permit was revoked because the zoning administrator determined that the short-term rental property is not the principal primary residence of the owner. Now, RS10, zoning area where only owner-occupied permits are available. This is governed by BL 2020-187. And again, the board's decision will be whether or not the zoning administrator erred in revoking the permit. On June the 3rd of 2020, the owner-occupied short-term rental property application was submitted. On August the 4th, 2020, the permit was issued and proof of residence provided was a pay stub and a bank statement. On October 15th, 2020, a red awning website advertisement was posted. On October 22nd of 2022, two website ads were posted, one Airbnb, one Booking.com. On December the 18th, 2020, HomeAway advertisement was posted. On July the 19th, 2021, the permit was renewed. On October the 9th of 2021, the short-term rental hotline call was made complaining that the nuisance at a short-term rental, fraudulent owner occupation. This was permitted as an owner-occupied property, and it clearly is not. This owner has multiple rental properties across Nashville, and the listing makes clear that he does not live at this home. On February the 10th of 2022, a Flipkey website advertisement was posted. On July the 20th of 2022, the permit was renewed. On December the 22nd of 2022, Inspector John Phelps opened an investigation on this property. The permit application package submitted had the following documents: proof of insurance certificate with a mailing address of 1109 Joseph Avenue. Tennessee Safety and Homeland Security address change confirmation with a mailing address of 1109 Joseph Avenue. The deed of trust for 3017 Hillhurst Drive, where the permit was issued, has a mailing address of 1109 Joseph Avenue. The Davidson County Metropolitan Trustee tax bill for 3017 Hillhurst Drive has a mailing address of 1109 Joseph Avenue. The Davidson County Assessor of Properties property record card for 3017 Hillhurst Drive has a mailing address of 1109 Joseph Avenue. The appellant, Mr. Robinson, does own 1109 Joseph Avenue. He acquired it on September the 5th of 1990. This address is assessed as residential. The appellant also owns several other properties in Davidson County. The details on those properties follow: 1636 Arthur Avenue. The Davidson County Assessor of Properties property record for 1636 Arthur Avenue has a mailing address of 1109 Joseph Avenue. The Davidson County Metropolitan Trustee tax bill for 1636 Arthur Avenue has a mailing address of 1109 Joseph Avenue. The quitclaim deed for 1636 Arthur Avenue from February the 7th of 2019 has a mailing address of 1109 Joseph Avenue. And states W. Daniel Robinson, a single man residing at 1109 Joseph Avenue, Nashville, Tennessee, 37207. The grantor's signature section of the deed has the appellant's signature and address, 1109 Joseph Avenue, Nashville, Tennessee, 37207. The 1636 Arthur Avenue non-owner occupied short-term rental permit application from 12/15/2016 expired. It has W. Daniel Robinson at 1109 Joseph Avenue. The owner occupied short-term rental permit expired application from June the 1st, 2018 has a proof of property tax payment receipt from Metropolitan Trustee with Willie Daniel Robinson, 1109 Joseph Avenue. The proof of insurance with the mailing address as Daniel Robinson, 1109 Joseph Avenue. 1104 Joseph Avenue, the Davidson County Assessor of Property record for 1104 Joseph Avenue has the mailing address at 1109 Joseph Avenue. The Davidson County Metropolitan Trustee tax bill for 1104 Joseph Avenue has a mailing address of 1109 Joseph Avenue. The special warranty deed has W. Daniel Robinson and send tax bill to new owner W. Daniel Robinson, 1109 Joseph Avenue. 1107 Joseph Avenue, the Davidson County Assessor of Properties property record for 1107 Joseph Avenue has the mailing address of 1109 Joseph Avenue. The Davidson County Metropolitan Trustees tax bill for 1107 Joseph Avenue has a mailing address of 1109 Joseph Avenue. The warranty deed has send tax bills to new owner W. Daniel Robinson, 1109 Joseph Avenue. 1510 Underwood Street, the Davidson County Assessor of Properties property record card for that address has the owner as W. Daniel Robinson and the mailing address as 1109 Joseph Avenue. The Davidson County Metropolitan Trustee tax bill for 1510 Underwood Street has a mailing address of 1109 Joseph Avenue. The warranty deed has new owner W. Daniel Robinson, 1109 Joseph Avenue, and send tax bills to same. 2400 Albion Street, the Davidson County Property Assessor property record for 2400 Albion has the owner as W. Daniel Robinson and Daniel L. Robinson, and the mailing address is 1109 Joseph Avenue. The Davidson County Metropolitan Trustee tax bill for 2400 Albion Street has the mailing address of 1109 Joseph Avenue. The warranty deed has new owner W. Daniel Robinson and Daniel L. Robinson, 1109 Joseph Avenue, Nashville, Tennessee. Syntax bills to 1109 Joseph Avenue. The Tennessee Secretary of State website has the appellant registered to vote at 1109 Joseph Avenue. The website has the voter registration data current as of March 6th, 2023. On two recent occasions, the appellant filed a detainer warrants that were filled out longhand with his address as 1109 Joseph Avenue, 37207, and his signature. A detainer warrant is the leading process of General Sessions Court used by a plaintiff in order to regain possession of his or her property from a defendant, usually one who has failed to pay rent. This warrant has a 30-day limit, and the court date is to be set in at least 6 days from the date of service. The warrants were filed on July the 8th, 2021, and December 5th, 2022. On May the 4th of 2021, the appellant sold 1404 16th Avenue North. The quitclaim deed has the appellant's address as 1109 Joseph Avenue, and the deed also bears the appellant's signature, which matches the signature on the detainer warrants. Four vehicles registered to W. Daniel Robinson at 1109 Joseph Avenue: 2012 Nissan Titan, 2017 Bentley Flying Spur, 2007 Toyota Camry, 2006 Mercedes-Benz CLS. We took the findings to the zoning administrator for review, and based upon the evidence gathered, he said to revoke the permit. The revocation letter was sent on January the 5th of 2023. By law, the Codes Department is required to give 15 days notice before the revocation goes into effect. Therefore, the revocation went into effect on January 20th of 2023. On March the 8th of 2023, Inspector Phelps made a site visit to 1109 Joseph Avenue, and the appellant's 2012 Nissan Titan was parked in front of the house, and Inspector Phelps made a photo. March 13th through the 19th, 2023, Inspector Phelps made site visits each night to 1109 Joseph Avenue, and the appellant's 2012 Nissan Titan was parked in front of the house on 13th, 14th, and 16th. Each night, the house was well lit. Photos were made on each visit. On the 14th, Inspector Phelps went to 3017 Hillhurst Drive, and the house was dark. No cars were present. To summarize the site visit, Inspector Phelps wrote, "On the nights of March 13th through the 16th, I went to 1109 Joseph Avenue and observed Mr. Robinson's truck parked outside on the curb every night. I noticed different lights were on for various nights, and I visited the property. Also, when I stopped by, the TV was on and could be seen through the front door from the street. On the night of 3/15/23, someone exited the front door." I took a picture, and I believe it was Mr. Robinson, and he signed that document. The last documented stay was November of 2022. The short-term rental appeal was filed February 8th of 2023. The website advertisements were removed on February the 7th, 2023, and there was one documented complaint which was described at the beginning of this presentation. The STR Appeal Board mailbox received one email in opposition.
Okay, any questions for staff before we hear from the appellant? And remind me, just as a point of clarification, because we have opposition to this case, the appellant has 10 minutes, is that correct? But should reserve some of his time if there's any interest in making rebuttal arguments to what we hear from.
That's correct. Both sides will have 10 minutes allotted to them. If the appellant wishes to rebut, they will need to save the time necessary to do so.
Fantastic. Great. Okay, so Gentlemen, do we have no questions for staff? Is that correct? Okay. Please.
I do have one. So there's you reviewed several records of property ownership in your information. So I was curious, when somebody comes in and applies for a owner-occupied permit, do y'all review that information in the consideration of issuance of that permit, or is it strictly a complaint-driven finding?
It's strictly complaint-driven. The staff that we have is very good and very efficient, but it's small. They have processed as many as almost 400 permits in a month. Wow. So you can see they cannot do an in-depth research on documents unless they have an indication that there is a need to do so.
Understood. Thank you.
And do I not remember correctly that it's not an affidavit, but there's language in that application saying that you attest to this being true and right?
Yes, it is an affidavit.
Okay.
It is notarized. And additionally, when the neighbor notification letters are sent out, when the applicant notifies them of their intent to apply for short-term rental property, it says that they will comply with the ordinance, and it tells them that what type permit for which they're applying. It also gives the neighbors the opportunity and the information as to how they can lodge a complaint, and if there is a complaint that is valid that would prevent the permit from being issued. In that instance, if we come up with a lot of times we get complaints such as we don't want it here. Sorry, that's not what the law says. So, but in the event that we have one that has merit and that has some substantiation to it, at that point, the application process will be stopped until the documents are reviewed.
Yeah. Go ahead.
I just want to confirm, the affidavit for this house, or this property in question is page 18 on the packet, correct?
Sir, I'll have to go through that. Give me just a moment, please.
Alicia, can you hit 18 out of 73 on your bar on the top? Okay. Can you zoom in a smidge too? Thank you. It's like a reading test, an eye test. I think we have seen, as Mac described, I think we have seen some occasions where the short-term rental activity never happened because someone they've appealed the decision that they were not to be granted one for the very kind of scenario you just described. I think we have had a case or two like that in the past. So it does happen.
I had one other question, just looking at so that there's owner-occupied permits issued for Daniel Robinson at both 503 Eastboro Drive, 1636 Arthur Avenue, and prior to revocation, 3017 Hillhurst Drive. Is that the same Daniel Robinson for those three properties?
I would have to look at the permits to give you exact information, but I believe that the arrangement is Mr. W. Daniel Robinson has one of those permits, which was for 3017, the permit revoked and in question today. The other is I think 1636 may have been a non-owner occupied permit, or it either is non-owner occupied or it's expired. And then, or perhaps 1636 is his son. There's Daniel L. Robinson, which is his son. Understood. So that's the arrangement. There have been three permits, but with two owners.
Thank you.
Great. Any other questions? Okay. Gentlemen, so you'll be cognizant of the time, keeping time available to rebut anything we hear from the members of the public who have joined us today. And as you get started, of course, give us your name and your address for the record.
If it please this tribunal, my name is Kenneth Quillen, Tennessee bar number 018858. I'm here on behalf of Mr. Willie Daniel Robinson regarding the Hillhurst property. And I'd like to ask Mr. Robinson a few questions to let him be on the record. And I wish we did this under oath. I think it would simplify things. But
We'll take that under advisement. So
Okay.
Mr. Robinson, could you please begin with your name and your address as well before you start answering council's questions? Thank you.
Willie Daniel Robinson, 3017 Hillhurst Drive, Nashville, Tennessee.
Mr. Robinson, how old are you?
74.
Have you been treated for cancer?
Yes.
Are you currently being treated for cancer?
Yes.
Okay. Now, you put certain properties or quit-claimed certain properties, a joint tenancy with right of survivorship to Daniel LaFrontes Robinson. Is that correct?
Yes.
Okay. Is that a part of your estate planning?
Yes.
Okay. Where did you sleep last night?
3017 Hillhurst.
How about the night before?
3017 Hillhurst.
Night before that?
Hillhurst.
You own multiple properties. Where do you prefer to lay your head at night?
3017 Hillhurst, if I don't have my grandbaby.
Okay. Now, where do you keep your grandbaby?
1109 Joseph.
Why do you keep her on Joseph Avenue instead of Hillhurst?
It's easier to keep up with a 4-year-old in a smaller area.
Okay. And would you compare Hillhurst to Joseph Avenue? Is it nice, newer?
Hillhurst is new, brand new.
Is it roomier?
Yes.
Does it have a big backyard?
Yes.
How big is the lot?
It's an acre, a little less than an acre.
How about the 1109 Joseph Avenue? How big is that lot?
About a quarter acre.
Okay. Do you have security cameras at Hillhurst?
Yes.
Okay. Do you have safe parking for your cars there?
Yeah, I park them all in the garage.
Do you own a fancy Bentley automobile?
Yes.
Okay. Would you park that Bentley automobile on the street on Joseph Avenue?
No.
Do you keep your clothes at Hillhurst?
Yes.
Do you keep toiletries at Hillhurst?
Yes.
Do you have a fancy wine cooler at Hillhurst?
Yes.
Do you have a fancy $3,000 or $4,000 refrigerator at Hillhurst?
Yes.
Okay. Back to Joseph Avenue. Do you have an office there where you can get your mail?
Yes.
Do you prefer to get your mail there?
Yes, that's my office. That's where all mail goes.
Okay.
For all my properties.
And all your business mail?
Yes.
Okay. What address is on your driver's license?
3017 Hillhurst.
And how long has it been 3017 Hillhurst on your driver's license?
I believe April 20, I believe.
April of 2020?
Yeah, I believe, yeah.
Now, the complainant was a woman named Melissa Cherry. Have you looked into Ms. Cherry?
I looked up on the internet as much as I could.
Who is she?
She works for the hotel motel business.
What motel does she work at now?
I think Legends. I'm not for sure now on that.
What are the room rental rates at the Legend?
Between $675 to $850 a night.
And before that, where did she work?
If I'm not wrong, it might have been the Lowe's Vanderbilt or one of the other up hotels.
Where do you find all this out?
On the internet.
Did you look at her LinkedIn page?
Yes.
Okay. Is Ms. Cherry a neighbor of yours?
Well, she lives in Parkwood Estates, so I don't know her personal address, but I would say anywhere from a quarter to a mile and a half.
Now, is Interstate I-65 between you and Ms. Cherry's residence?
Yes.
Okay. What is your primary residence?
3017 Hillhurst Drive.
Okay. One quick question about that garage at Hillhurst. You've got locked garages there?
I have 4 garages there.
Okay, all
Four
right.
two-car
And how many
garages.
cars can you fit in at Hillhurst?
Probably 5 or 6.
Inside the garage?
Yes.
Okay. That's all I have. Question?
Counselor, did you see that you had a photocopy of Mr. Robinson's driver's license?
I do.
Want to share it with us?
I do. I didn't bring 8 copies, but
That's whatever
I
you
will
share and pass it
leave one to the council there. And I'll make Ms. Cherry's LinkedIn account an exhibit too.
I don't think we're interested in that.
And I apologize. Procedurally, are we, just to make sure I'm clear, do we need to allow the opposition to speak first before we begin questioning Mr. Quillen? If they are done in their presentation?
Oh, the opposition?
Yes.
Okay.
No, you can,
I just want to clarify this. There is an issuance date on here.
Right.
And this was issued 1/28/2023. So it wasn't as it
You're
was
looking at
represented.
a duplicate. You see it says DUP at the top right? In the materials you provided, the Tennessee, or they used to call it Department of Safety, now it's Homeland Security. It notes that that change of address occurred on April 29, 2020.
And we don't have, okay,
That's in
We
the
have
record
that
submitted by
from-
Mr. Broom.
got it.
And I don't know what the,
And Alicia, can you help me find the page for that?
what were you looking for?
Okay, so if this is a duplicate that was issued 1/28/2023, it doesn't really speak to anything, so I don't know if we need any more copies.
there's the address. I don't know what page that is in your,
She's finding it.
Just as a point of information here, to clarify, in your rules, it says that any member of the board may directly question a witness at any time during the testimony. Saying that gives you a lot of leeway in terms of when you want to direct your questions.
Oh, perfect.
when you're
Okay.
presenting it.
If I may, or
Please.
I apologize. I'd like to, Mr. Quillen, I'd like to actually discuss the voter registration that that was included as part of the packet. Would you agree that the right to vote in the state of Tennessee and your assignment of your voting precinct depends on or is determined by where you declare your primary residence to be?
certainly, and I have advised Mr. Robinson to make sure he conforms to the law. He hasn't as of yet, but voting is something he only thinks about once every couple of years, so.
Okay. Would you also agree that you are legally required to confirm or deny whether or not your last recorded voting address is correct and change that, in fact, before you are allowed to legally vote in this state?
That has been my experience.
Okay. So could you please help us understand why it is the case that you just solicited testimony saying that this has been his address since April of 2020, and he all simultaneously has participated in at least one election since that date where there is a conflict between the address on this piece of paper and his residential address from which his voting rights in the state of Tennessee flow?
Well, I think he probably early voted and, just went through the forms and didn't think about it like he should have.
There is a question that the intake person asked. They asked you to affirm or deny whether this address information is correct.
And he may have just forgotten that was, he was required to put his actual residence and not his mailing address. 1109 is still his mailing address as far as business mail goes.
Let's move on to the detainer warrant. Would you agree that a detainer warrant is a sworn statement and that it initiates legal process in the state of Tennessee?
No, it's not at all a sworn. Well, part of it can be sworn, but the information where you put your contact information on the right side of a detainer warrant is just information for contact purposes.
So I could put in, if I wanted to say I lived in Juneau, Alaska, you're saying that the state of Tennessee would hear my case based on my indication that I live in Juneau, Alaska.
Well, if you owned a piece of property and were going into general sessions on the detainer warrant, it really wouldn't matter where you lived. The only question is where the sheriff needs to notify you of the court time. That part's not under oath.
Okay, so why would he file 2 detainer warrants then, listing that as his address?
It doesn't list, it's just a mailing address for the purposes of a detainer warrant. I mean, a lot of times they'll put the attorney's name down there or just the attorney's telephone number. Okay. That's generally what I would do when I file one, and I have filed detainer warrants for Mr. Robinson in the past.
Okay.
Thank you all for being here. And to the attorney, I'm sorry, I forget your name.
Kenneth Quillen, Quillen.
Kenneth Quillen, yeah. So that was an interesting format. We've never quite had that. We've also never had someone share personal information about a member of the public who complained about a short-term rental property. So I'm curious what you think the relevance of Melissa Cherry's work experience is to this case.
Well, she is a direct competitor. She works for a motel or a hotel that's renting rooms for over $600 a night.
How close is that hotel to this property?
Well, I don't even know where the legend is. I assume it's in Nashville somewhere.
You consider them direct competitors?
I would.
That's why
I think Airbnb
so the assertion,
is a direct competitor.
The assertion is that member of the public is using the complaint system for short-term rental properties, submitting false complaints to.
Well, I'd
the
say she's an
employer.
interested party. I'd be willing to bet she's made other complaints.
I mean, that's
maybe
she's
Mr.
not here to
Broom
defend
will
herself, and you
address
can,
that.
I guess, sort of throw that out there, but there's really no way to tell, is there?
Well, I'd say Mr. Broom can research it.
But as of right now, it's an unsubstantiated claim, correct?
I'm sorry?
As of right now, that's an unsubstantiated claim, correct?
What's
Yes
the-
or no, it's a yes
I
or no
don't understand
question.
what you're saying.
It is an unsubstantiated claim that you don't know whether or not she has made other claims against short-term rental properties. Yes or no?
What I said was that I would be willing to bet she has made other claims.
Right.
That's,
Okay.
I don't know.
All right, moving on.
Moving on.
Where did your client file his taxes?
Where did he file his
Where did he file his taxes? What address is on his taxes?
Have you filed this year? You hadn't filed this
Last year.
Where did you file last year?
All property taxes and state taxes, federal taxes go to 1109 Joseph Avenue.
Yeah.
That's my office, that's my business.
Okay,
Okay. Just to clarify, I don't think there's any mistaking this. 1109, while you're referring it to as your office, it is a home and is a residential property, residentially zoned. Is that not correct?
I have my office in there.
Not debating that with you, sir, and I have very little interest in debating you at all. I just want to clarify, it isn't an office like an office building on commercial, on a commercial avenue. It is a home where perhaps you have your home office, fair enough, but it is a home, correct? It's a home. It's a home that you.
It is a residence. It has bedrooms, and I'm sure he's got extra clothes and everything else there.
Okay. Very good. Any other questions before we hear from members of the public?
I guess for the office at 1109 Joseph, do you have a home occupation permit for that office?
I filed it on my taxes.
So you deduct it on your taxes, but you don't have a home occupation permit from the city?
I haven't never been told I had to have a own office
Okay,
from the
thanks.
city, yes.
If you deduct it on your taxes, that brings me to another question. Do you deduct the entirety of the building so that you don't use it as a
No,
home?
just
you
my office.
just the office building. Okay. Okay. Any other questions? And I was keeping track of the time myself, and the allotted time for 10 minutes was had whittled down to about 6, or we'd used about 6 minutes. Does that sound fair? So 4:34 is remaining? Okay, so keep that in mind, gentlemen. We're going to ask you to step aside to make room for some members of the public. We'd love to have any and all step forward, but let's keep in mind that we have just 10 minutes to hear. So amongst those who want to speak, if you could kind of decide, and we can coach you along, but would you decide how much time you want to speak, and make sure that enough time is allotted for your neighbors?
Yeah, for clarity, y'all get 10 minutes between the lot of you.
Right.
So all of y'all together get 10 minutes. So just make
Yes.
sure to share it, make sure everybody gets a chance. Thank you.
And the rules apply as well. So you're going to want to open the microphone and share with us your name and your address before you speak. Okay? The little person with the just one time. It'll turn red. The right one, precisely.
Okay.
Okay, great.
My
Go right
name
ahead.
is Billie Jean Regan. I live at 2958 Hillhurst Drive. I have lived on Hillhurst Drive for 31 years. I moved out there August the 1st, 1992.
Very good. And did you want to share a little bit of what brought you here today?
What brought me here today was the concern for my neighborhood. I got in the letter where we were appealing the short-term rental. It is a resident area, as well. And I too, since he was sharing, it is a breast cancer survivor. So, so we come together because we're concerned about our property. Our property is our investment,
Yes, ma'am.
as well. And I don't want to get in too much, but I have never met Mr. Robinson.
I don't want to use up your time inappropriately, so let me be very quick when I say, do you see the gentleman coming and going from the neighborhood? The claim that was just made was this is his home, his primary residence, this is where he lays his head every night. And you live in the neighborhood and have for 30 odd years. Is that factual in your estimation?
No, that is not factual. As a matter of fact, 3017 is like a duplex, and it has high stairs. It would be sort of difficult, for someone to go. As we get our age, it's difficult to go up and down the stairs. And there are 2 garages, so there are 2 separate homes.
Understood. Thank you. Please. Go ahead, sir.
I'm Michael Shoemate. I live at 3004 Stanwick Drive. I've been there about 10 years. It was my mother's home before me. I like our neighborhood, especially in the sense of a community, not just in terms of flipping houses or whatever, or what's financially attractive. That means a lot to me. I've been under the impression that there was pretty much no one at this house on Hillhurst. I live literally around the corner. So when I walk around the block, which I do a lot, it's like, zero happening. That's just my observation. I don't do it 3 times a day or anything, but anytime I've gone by there, there's just nothing going on. And I've not seen Mr. Robinson. I didn't know who he was. I guess that's about it. But I was under the impression that this was not owner occupied. And my concern there is simply that if it's not, then it's a commercial venture in a residential neighborhood. So that's kind of all I had to say.
Thank you, sir.
My name is Ben Wiley, and I live at 2904 Rich Acres Drive, which is several blocks up from this resident. I am the president of the Hillhurst Homeowners, not Neighborhood Association. And this property has been a concern of ours for some time. First of all, as it's been pointed out, it has high steps. And I've never met this gentleman. I've lived in this neighborhood for 30 plus years. Really approaching 40 years. I've never seen him, never met him. As he's pointed out, he has voted most recently, not in the neighborhood, but at his home office address at, 1109, 1107, whatever it is, Joseph Avenue. And that's really is the concern of the neighborhood, that I'm not against anyone making money, but don't do it under false pretenses. And that's what has been done in this instance.
I'm concerned about running out of time. So for members of the board, were there any questions that you had for the neighborhood folks who've joined
Chair
us today?
Caputo, I just want a point of clarification. When you ask questions, the clock
You
is
stopped
stopped.
the clock. Okay, good. Well, then we've stopped the clock. So anyone have any questions? And Alicia, how much time is left, just in case? 6 seconds? 6 minutes? Oh, goodness. If there's anything else you folks want to add, I'm so sorry I butted in. Is there anything more you wanted to add?
I wanted to add, I do walk the neighborhood, and what I see is different cars parked there different time, because I walk quite frequently, in our neighborhood. Thank you.
Very good. Anything else you want to add?
No, I would
Okay.
certainly, abide by what the council has voted on. That's
Okay.
what I would ask. Thank you.
Thank you so much, folks. We greatly appreciate your time and the trouble you took to come down here today.
And
I'm quite sure we'll want to hear from the
One
Go right
moment.
ahead.
I'm sorry.
No, please.
But there are parties. About a month ago, you couldn't get down Hillhurst. There was cars parked on both sides, and that's the reason why we are concerned about that property as well.
Understood. Very good. Okay. Thanks so much, folks. So remind me, we have 4 minutes and how much time remaining to hear from the appellant and his counsel again? 5 minutes and 30 seconds. Okay. Mr. Quinlan, did you want to, please, sir, please return to we need to have the microphones running. And if Mr. Robinson is going to speak or continue speaking, he'll want to come up to the desk too.
I just want to add that 3017 Hillhurst is in a floodplain, and that's why you have to have stairs and garages on the first floor. So.
All right, let's not have too much peanut gallery over there, folks. Hey, all right, folks, let's keep the crosstalk, y'all. Let's keep the crosstalk down, please. All right, folks. The public hearing is going to be deemed closed, so let's not have any more public comment. Thank you. All right. Does anyone on the board have any questions any further questions they would like to pose to staff or to the appellant before we discuss this amongst ourselves?
No.
Well then, take it away.
I'm not for 1 second convinced that 3017 Hillhurst Drive is Mr. Robinson's residence. I am very challenged to believe that he would be permitted to, on multiple occasions, make false statements to poll workers in order to exercise his voting rights. Therefore, unless there's any other discussion, I would move that the zoning administrator did not err and that the decision stands.
Second.
Sorry?
I'm inclined to support that motion, but I do want to point out, one of the comments from the general public, I believe the term was a commercial venture in a residential neighborhood. That is a meaningful designation at this point. So the state of Tennessee now taxes non-owner occupied Airbnbs as commercial property. So, really we're running into more issues than just permits being issued incorrectly here. We are potentially running into issues with property taxes not being paid at the commercial rate, which is what non-owner occupied properties should be paying. And I hope that we can find ways to kind of get a handle on this issue more broadly. But I just wanted to make that note. I'm going to be supporting the motion from Commissioner Bond.
So, Phil, anything before we vote? I think, I'm leaning towards supporting your vote as well. But I think that in this one circumstance, we very often hear from members of the public, and seldom have we had such wide representation of a neighborhood who can say, I've lived there for this amount of time, and if this person's primary residence is this house, that's news to me. I thought that was the most compelling piece, aside from all the substantial documentation. So, since we have a motion, shall we see a show of hands who supports the motion?
Wait, was there a second?
There
Oh,
was
I'm
a
sorry
second.
if it was a second.
Yeah.
I apologize.
How could you forget Phil?
Sorry. My brain.
Okay,
Very slow.
the motion carries, and the zoning administrator did not err in this case, and therefore there will be no relief offered. Thank you so much for your time today, Mr. Quinlan, and thank you, Mr. Robinson.
Thank you to the board for your time and consideration, and I do appreciate it, Ms. Kimberly, nothing personal. I was just trying to be a zealous advocate, and I wish you all the best.
Okay, thank you. Okay, let's call today's hearing closed.